Today, we discuss the strategies behind licensing. We will talk about developing the licensing strategy, the business issues relating to the licensing strategies, and tips for interacting between licensees and licensors. First, let's get into the basics. What is a license? A license is an agreement in which rights are granted by one party to another under an issued patent application, or copyright, or trademark, or other IP rights. Tangible materials and software may be licensed as well. The license document captures the terms of the business agreement, and the license is a legally enforceable contract. The goal is to facilitate the business agreement between the licensee and a licensee. Let's talk about what drives the business side of a license. First of all, you need to discuss the license assets, the financial terms, as well as the non-financial terms. And those non-financial terms relate to diligence and reporting and indemnifications, for example. From the licensor's perspective, it creates an impact for their innovations. It disseminates the research, the result of the research for the public good. There are also government requirements such as Bayh-Dole compliance. It results in economic development, generates funding for the licensor, and it satisfies, in the case of universities, various institutional metrics. And it also helps the retention of the investigators who would be financially be benefiting from the licensing and the resulting revenue share. Industry would license the technology if they gain a competitive advantage for product commercializations. So potentially the patent license may provide improved profitability by decreased competitive pressure, i.e. with a patent, you have exclusivity and that keeps out competitors. You can also leverage the affiliation with the university, with a particular university. For example, if the technology came out of IBM Research Lab or Harvard Research Lab, you can say, hey, that technology is coming from a renowned research institution. It must have some particular advantages. Licensing may also be used to increase the speed to market, increase startup valuations from the perspective of investors, because now when you license the patent, you have a larger patent portfolio. There are strategic financial advantages in licensing other IP because you'll save the R&D expense. And another reason for the industry to license is they can generate sub-licensing revenues, as well as mitigating risk from the freedom to operate. So for startups, the patent license secures fundamental assets to build a product, increases the company valuations from a prospective investor due to a larger patent portfolio, and that can help in a future acquisition, or the patent can also be used as a third-party funding milestone. For a non-practicing entity, the entity can generate revenue through enforcement and licensing of the patents on behalf of the patent owner. For an existing company, they may license the patent to get competitive advantage, reduce the product development timeline, mitigate risks of enforcement by the patent owner, and you also obtain a defensive position in a crowded patent space. What are the potential alternatives to licensing? Of course, you can design around. You can decline a license and design around. You can develop and commercialize alternative product that does not infringe issue patent. Or alternatively, you can commercialize the product for sales in non-patented jurisdictions. So what's an example? If the patent happens to be only US and now you sell it in let's say in Europe or in Japan, there's no patent over there, therefore you're free to sell. You can also, as another alternative of licensing, you can challenge the patent to delay its issuance or to dispute its validity. Or you can also enter into an option agreement to cap the downside risk with the patent owner. Of course, if you've not been approached yet, you can always establish an invalidity or non-infringement position and be prepared to defend against the enforcement. Another common approach is to not license based on an opportunity cost. Next, let's talk about developing the licensing strategy. First of all, are you an existing company or a spin-out or both? Are you a market leader or a new entrant? What kind of exclusivities do you want? How many licenses do you consider? And also, what is the licensee's track of success? Because the licensor success is tied to the licensee success. And that result in the question of what impact does the licensing strategy have on the licensees? Let's talk about understanding the licensee's business model. The licensee needs to consider the value of the product or the service. What is the licensee's view of the market and competition? What is the licensee's business model? How will they make money? How will they finance the business? Who is the customer for the product? Reimbursement, price control an issue, and what's the role of the sub-licensees or distributors of the product, and what are the milestones associated with the license? Another set of question is, how important is the license IP to the company? If the license IP is only just affects a minor fraction of the product, then the licensee can negotiate hard on to lower the cost of the IP. However, if it covers the core functionality or the core value of the product, then the negotiating position is reversed, and the licensee would be in a weaker position. Another question to ask is whether or not the patent provides an actual monopoly or blocking position. Is it bundled with other patents? How does that affect the deal structure, the royalty stacking, and the combination of the patents? How does it affect that? Does it provide freedom to operate? And is this patent a necessary to have or a nice to have? Similar to the questions found by most startups. Is our product absolutely necessary or is it a nice to have? And another factor in there is the geographic scope of the IP. Is it global? Is it United States or is it a particular state? The licensor and the licensee should be focusing on capturing value and the long view. So, of course, pre-commercialization, you should discuss the license fee, be it cash in case of a big company or equity in case of a startup. So for universities, often it's as equity, as the licensee fee. The value can be captured in terms of the commitment, opportunity costs to the licensor, and also the licensee credibility. As a licensor, if you're a university, you can point to these factors to positively increase your license fee argument. Also, as a university, you might want to look at the expense reimbursement, typically the patent cost. The universities may want to think about the development milestone payments. Is this per country? Is it per license product? What kind of risk reduction is done? And there's also maintenance fee payments and things like that to be considered by the university. Once you're at commercialization stage, a university may want to consider the royalty. Is there any annual minimum royalty, and then also is there a running royalty on the patent? What kind of sub-license fees would be assessed for in case the licensee then in turn sub-licenses the invention? Are there tiers? Do the fees decrease over time? What about sales milestone? The university may want to insist on a sales milestone to ensure that the royalties are appropriate because they're based on the sales. And another factor the university can consider is the sharing and the financial benefit of the IP on absolute or relative basis. Let's discuss capturing value and the long view. So there are fixed fee agreement as well as the fully paid agreement. So when a licensee takes a long view, they prefer a fixed fee and they prefer fully paid agreement. So that way, if they have more sales, it doesn't increase their cost. There's also the issue of research support. What is the value of the strategic relationship with the licensor? What's the value of the research cost today versus potential value in the future? And what if licensor or licensee is not interested in collaborating with each other? Those are factors affecting the license terms. In terms of capturing value in the long view, the university may want to consider the value of equity. In case of Stanford, they did very well when they licensed Google. And so equity ownership is great. However, as the VCs have stated, 9 out of 10 companies fail. So if you take equity, you have an odd of 90% that it's going to be worth nothing. This has to be balanced against the fact that the startups are cash poor. So therefore, most universities basically take a percentage of the equity. The numbers range between 2 to 5% of the equity. And so the equities provide that initial return, even if the products fail, but the company succeeds with another product line, or if the company changes its strategy away from the license IP. The equity serves another different purpose than the royalty, and it is not a substitute. It is a valid substitute for upfront financial payment because startups don't have that money. So in taking equity, the patent holder needs to determine whether or not there's anti-dilution and down round protection for them as an early investor in the company. Also, you might want to consider whether or not there's going to be cash or in-kind co-investment by the universities. In many cases, participation rights are preferable because if you manage to lock yourself to a fast-rising company or a unicorn, as they call it, you want to be able to maintain your participation right so that you will keep your pro rata ownership of that unicorn that you managed to capture. However, the value of equity is, so the short of it is the value of equity in a startup can rapidly increase, and experienced investors won't invest without the prospect of a 10x return. So the return to the licensor on a strategic value is based on the IP. And so the equity gives a return if the products are based on the licensed IP and the product fails, but the company succeeds with something else. So it gives the universities or the patent licensor another leg for the exit. The downside of equity is that it's illiquid until an IPO or an acquisition. And value can be destroyed if the company needs to raise more fund and they don't have enough traction, so therefore they have a down round, and existing shareholders can be diluted. There's also governance and participation issues such as preemptive rights, shareholder agreements, distribution to inventors. Next, we talk about the grant of rights. So the grant of a license, you need to consider whether or not it's exclusive or non-exclusive. What are the licensed assets? Are they patents only or patent and patent applications? Are there others such as copyrights, trademarks, know-how, trade secrets, tangible materials, software, data, etc.? Also, you need to consider the field of use. The field of use is actually separate than the territory. So the field of use, you can partition the invention to specific applications, such as only for heart treatments and only for diabetic treatment. And so by parceling out the field of use, the patent owner can extract more value. Similarly, in the territory, the patent holder can designate whether or not it's country-specific or global or least developed countries. Last but not least, the license agreement should discuss the retained rights to the patent owner. The grant of right can also contemplate how to handle improvement in the technology. So let's say if the same inventor has made additional improvement, does that improvement accrue back to the patent holder, or is it a shared project? And also, how long is the rights to the improvement accrue back to the patent holder? The grant of rights should also talk about sub-licensing issues. And of course, the issues are whether or not the licensee is permitted to do this, and whether or not they need to notify the owner of sub-licenses. Are there limits on the number of licenses, sub-licenses? What about territory and field? And also sub-licensing fees that are provided back to the patent holder. In the grant of right, you might want to talk about key business issues, such as you need to understand the licensee's business model, know how the licensee plans to make money, decide how and how much to capture this profit, and ensure the scope of the grant, definitions of the revenue generation activities, and royalty language are all internally consistent. Now, there's also diligence aspects of checking out the licensee. Diligence works both ways. The company can check the technology, and also the licensor can check the viability of the licensee based on the business model, on the time they're in business, financial funding, etc. So in the due diligence phase from the patent holder side, you need to understand the licensee's development plan, the milestone, how they were achieved. You need to anticipate that product development will not go as planned, and then what's plan B, and put that into the agreement. Understand what is in the licensee's control and what is not. The point of negotiation is the explicit right to terminate upon failure to reach the milestone. And this is different than the good faith negotiation to renegotiate the milestones. Of course, you need to consider the financial return. So what are the considerations for the grant of right? It can be money or it can be in-kind consideration, such as products or services, cross-licensing, agreement type, and then you have different types of compensation. Upfront or license issue payments, and it could be in cash or equity. And also you can consider annual license maintenance fees. That's for a pre-sales company. Of course, for companies with sales, you need to put in terms for running royalties based on the sales. What about the pass-through to sell by sub-licensees, patent versus unpatented countries, and royalty stacking? So for the financial terms, the key terms should be sales, net sales, permitted deductions from the sales, licensed products, and enable products, and then sub-license and sub-licensee income. And those are the key considerations for licensing a particular technology. We hope that this discussion is helpful. And if you have any additional questions, feel free to reach out to us at patentpc.com. We look forward to hearing from you. Thank you.